There we go. It's a little throw into my mediation settings. I always have that set up. And with that, we're going to get underway. So it's 6:07 p.m. I want to welcome everybody tonight to this wonderful meeting of the New York County Lawyers Association's ADR Committee. We have a very special guest, Mr. Jeffrey Zaino, from the Vice President of the American Arbitration Association, who is going to be speaking about how arbitration, as well as, I guess, ADR in general, has changed in light of COVID, what the AAA is looking for in arbitrators. And of course, we're probably going to have a ton of questions afterwards. That's why we're going to be front-loading our program tonight with Mr. Zaino. I just want to kick things off very quickly with a prelude. We have an agenda for those people who are committee members. Let me just say, first of all, the ADR committee is planning great events like you have tonight. So if you're interested in joining, please send me an email, or Nelson Timken, who is our vice chair, or Chris Fladgate, who's also on tonight. They're all co-hosts and will probably be helping me in handling questions. Send them an email, and we'll put you in touch with the people at NYCLA who can get you on the ADR committee. Okay, so just to go through the agenda for those people who have it, actually what I'm going to do is I'm going to share out my screen so everybody can see that. So time. Okay, yeah, that should be it. There we go. And we got through introductions, so welcome everybody. It's upcoming events that we have. I'm just going to introduce these very quickly. On October 28th from 6 to 8 p.m. With a 30-minute virtual nightcap we're going to have afterwards. The panelists have agreed to stay on to answer questions. Sure, we're going to have them. We have starting and maintaining successful ADR practice in the age of COVID-19 and beyond. You see the faculty over here. We have Jess Bunshaft, Theo Cheng, Marilyn Genoa, as I said before, she's sends her regards. Jennifer Lupo, Chuck Newman, and Michael Starr. So you got effectively, including myself and Chris, you have 4 chairs right now of ADR committees, various bar associations. We're going to be all getting together to discuss how to start and maintain a successful ADR practice in the age of COVID-19 and beyond. You see the topics over here for those people who are on phone. I'll just briefly read them. We're going to be discussing qualifications, certification programs, incorporation, networking, mentoring, and shadowing, accounting, revenue generation, getting paid, always a big topic, getting experience, joining panels, insurance, risk management, and more. So please, mark your calendars for that. Very equitably priced, and this is part of a probably at least a 2-part, maybe a 3-part, we have yet to decide series, with the second part being in December. Again, this is not just a pep talk or war stories, but concrete information and how to start an ADR practice from the experts who did it themselves. So it should be a very interesting evening. Then coming after that, we have what I call entrenchment mediation training, and that's to be taught primarily by the Appellate Division 2nd Department Mediation Program, Mandatory Mediation Program Special Masters. It's going to be kicked off by Carol Swidler. That's going to be on, who's the Assistant Deputy Chief Appellate Court Attorney for the Appellate Division. She's basically their ADR coordinator and does a phenomenal job dealing with that program with hundreds of cases, if not even thousands at this point. That's going to be on November 10th, 2020 from 5:15 to 7:45 p.m. Just very briefly, let me explain what the term entrenchment means. In this particular program, in the Appellate Division Mandatory Mediation Program, the parties have already done their briefing. So they're already post-perfection and they're ready to go to oral argument. And effectively at this point, there's not much of an incentive for them to mediate. So they are coming into the mediation process with reservations as to first coming to the table in the first place and then staying at the table. And the idea behind that, being that they're so entrenched, that's what the term means, is to come up with ways for mediators to encourage them to go forward with the process and to break what the special masters know as the 90-minute barrier. You see that in the description over there, which basically under the rules, the first 90 minutes is given gratis to the parties, and afterwards they stay on to pay the mediator's agreed upon rate. So the question is, how do you get past the 90-minute barrier? And then even when you do, I thank God I've been able to do it twice. The people who are going to be speaking have done it many times, particularly Pierre Derival de Slapon. He's done it numerous times. But all of them are phenomenal at what they've done. And they're all senior special masters. They'll be speaking about that and also how to surmount impasse, even if you break the 90-minute barrier. There's a significant amount of impasse given that the parties have already done their post-perfection work. So that's coming up on November 10th. Also, other works that are in progress, and we're just going to go quickly through them. Part 137 is the NYCLA's attorney-client fee dispute resolution program. We handle the cases for that program, which is state-run through OCA from both New York County and the Bronx. Right now, we're working with Anna Marie Bova, who's NYCLA's general counsel, to revamp the program so as to conduct arbitrations and mediations, because NYCLA actually has Part 137 mediations virtually. So we're retooling that program right now. I'm actually, along with Chris and Nelson, in charge of it. And just to give full disclosure, we even have ongoing active ones now. We've already started up. I have a tech check coming up this Wednesday. So it's a great thing to have to be a part of, to serve the community. And then we hope that people who are interested in that here, when that training is announced, we're probably looking at December at this point. We actually already have a tentative date of December 9th. We already have Professor Grant Hanasian lined up from Fordham. He's going to be discussing the Part 137 arbitration prong on that day. And the second day is still to be determined, but that's moving along very nicely. So please take a look at the announcements. And if you're not a member of NYCLA, that'll be posted on the NYCDR listserv that Maria Volpe runs as well. Okay, we also, just very quickly, have plans later on, probably in winter, spring 2021, for bankruptcy mediation training, an international arbitration CLE. Nelson, by the way, is just so everybody came on afterwards, Nelson Tipkin, our vice chair. Just to introduce him again, he's taking international arbitration right now with Fordham as part of an LLM program. So we're probably going to have some of his professors presenting at that. And then we're also planning on doing a basic mediation training probably much later. That's going to be in the spring or summer, looking at things. So we got a lot of great events planned. With that, though, I'm going to move into the main event for tonight. Let me introduce Jeffrey Zaino, from Vice President of the American Arbitration Association. Jeff has been everywhere. I can tell you, going back to 2015, with the NYSBA's annual commercial commercial arbitration training, which is run with Charles Moxley, Edna Sussman, Leah Cook-Haber, and a bunch of other people, which is a great program. Met him there, and I can tell you he's been a master at arbitration events in terms of being present and advancing arbitration in New York. So it's a phenomenal privilege to have him tonight and to address us. He's going to be speaking to us for whatever he wants. We're thinking about 45 minutes. But I'm sure there are going to be a bunch of questions. So if you want to go for an hour, Jeff, the floor is yours. Tonight's topics are going to be on AAA operations in the age of COVID, arbitration opportunities in the New York metropolitan area, one of which I just told you about before. When we get the Part 137 program started up again, you'll have some opportunities there, though those do go very quickly. And what the AAA is looking for in prospective arbitrators and mediators seeking admission to its panels and rosters of neutrals. So without further ado, I'm going to stop my screen share over here, and I'm going to turn it over to Jeff.
Great. Thank you so much, Ilan, and I really appreciate this. It's great to see everyone here today. And I think I know a lot of you, and I'm recognizing a lot of faces. This is terrific. I want to thank the New York County Lawyers Association, ADR section, Ilan and Nelson, for this opportunity tonight to speak to you. It's great. Please feel free to ask questions throughout when I'm talking. I'm going to be talking for about 45 minutes. But we'll also have a little time at the end. But if there's something you want to ask when I'm mentioning something, please just unmute yourself and ask me. I do this quite frequently with law students, and I did with Nelson's class the other day, and I don't mind being interrupted, trust me. So with that, I will start off with, I got some advanced questions. The first question was, and I'll just read the question so you guys will know what I'm going to be talking about, the nature, type of arbitration services that AAA provides and how the pandemic has changed the way AAA provides arbitration services through, for example, technological options such as Zoom arbitration. So what is a AAA and what have we been doing? Okay, well, the AAA is the largest ADR provider in the world. We do about 300,000 cases a year. A lot of people are surprised when they hear that. 300,000 cases per year, okay? And we have 6,000 arbitrators on our panel, 6,000. 25% of our panel is diverse. We're very proud of that. There's been, some talk about this area that we're in is not too diverse, but 25% of our panel is diverse. AAA has 600 employees across the nation, 26 offices in 18 states, and we have an office in Singapore. We just opened an office in Singapore about a year ago, right before the pandemic. Okay, and our company, our staff is 65% diverse. So that's the makeup of the AAA. Now, we started in 1926. 1926, 1 year after the Federal Arbitration Act was in 1925. I mentioned this because it's kind of interesting. We moved our office space, and I was a part of this. We moved our office space from Midtown to downtown in 2013. And it was kind of interesting. We moved right across the street from our original office at 120 Broadway. Our headquarters is there at 120 Broadway right now. I'm actually not there. I'm actually in Midtown. A lot of you probably know that know me. My office is right across the Chrysler building. But we do have, like I mentioned, 26 offices across the nation. Now, I wanted to talk about the types of cases that we've been doing since 1926. Our first caseload was labor. Okay, that was our legacy caseload. We only did labor initially, and the arbitrators did it for free. Nowadays, arbitrators don't do it for free, okay? But in 1926, they were doing it for free. But since then, we've grown tremendously, okay? And tremendously. And a lot of you that are either on our panel or know about us know that. I'm in commercial. I do commercial arbitration, but we do insurance. We do construction, international, employment, and consumer, okay? And the two areas that we're criticized in are the employment and the consumer area. I just wanted to briefly mention that. And why I want to mention that is because it kind of gives arbitration a bad name, and we kind of at AAA get upset about that because we feel like we're kind of the good guys. So does GM, CPR, and other ADR providers, because we don't write ourselves into contracts. People write us into contracts. Okay, so we're written into millions of contracts every year. People are writing us into contracts all the time. We can't control that. And obviously in consumer contracts and employment contracts. And those two areas people have an issue with because it's a contract of adhesion, as all of us know on this call right now. And our position at AAA is, well, we have a due process protocol that we introduced in 1996 for employment and consumer later on. And the due process protocol is trying to level the playing field because most of our business is B2B, business to business. But in these two areas, we get criticized, okay? And there was a New York Times expose about 3 or 4 years ago about these two areas. But our position again is the fact that we don't write these contracts, and we're put into these contracts, but we have these due process protocols that level the playing fields. And how do they do that? Well, employment. When I started at AAA a long time ago, I started in 1990. I'm dating myself. Okay, so I've been at AAA for 30 years, but we didn't have the due process protocol. We didn't have employment arbitration rules, and now we do. And what we do is we have this due process protocol that says, okay, now if you file a case with AAA, the employee has to have the right to select the arbitrator. They didn't have that before. They have to have the right to discovery. And a lot of other things, okay? So we tried to level the playing field in employment. And then in consumer, a couple of years ago, we have, everyone has cell phones, and we're written into a lot of cell phone contracts, like AT&T. I have an AT&T cell phone, and it calls for AAA. And what we have now is a registry where you have to sign up with the AAA, and if you're a company, and say that you're gonna meet these certain standards. And a lot of people don't know this, that we reject cases every year. About 350 cases we reject every year if they don't meet these due process protocols. So again, I'm not waving the AAA flag or GMs or CPR, but we're trying to be the good guys. We're trying to say, okay, let's level the playing field. And I think we are to some extent. So AAA also, back to our history, in addition to cases, that I mentioned. We also do a lot of other things, and we're not for profit. We do publications. Okay, we publicize. I mean, we do the Dispute Resolution Journal, and we do a lot of programs, a lot of educational programs, and we're not for profit. And one of our goals is to educate people, not necessarily about the AAA. I know I have my little AAA logo behind me, but when I go out and speak about ADR, it's not about AAA. It's more about, I think, the benefits of AAA. I mean, the benefits of ADR. And I think all of you appreciate that. I mean, all of you in this committee appreciate the benefits of ADR. Also, and probably a lot of you don't know this, the AAA also does elections, actually ballot counting. And I was actually in that division at one point, the Labor, Employment, and Elections Division. And what that means is we do it for the police unions throughout the country, the teacher unions, New York City. The New York City ballots are all done by AAA. The Chicago teachers, California, the LA teachers. And the reason they hire us is because we're a neutral organization. And sometimes we get an arbitrator involved in that. An arbitrator has to make rulings on certain things. And the reason they hire us is because we're a neutral organization. And we do about 300 elections per year. I mean, so that's a pretty big business for AAA. Where we're different in comparison to our competitors, and I said we're the largest, is because we can do very large claims, okay, very large mass claims. And one example, and probably a lot of people on this call today, or Zoom call, have done Storm Sandy claims, okay? We can do those. AAA has a big staff. I think it was 2013 or 2012, we were able to mobilize our staff and mobilize about 200 mediators to do about 6,000 cases. We did it in New York. We did it in New Jersey. We did this also for Storm Katrina, which was a few years before that. So these are things that we do as a not-for-profit. We didn't make a lot of money on it. The mediators didn't make a lot of money on it. They were making about, I think, $350 per case. They were kind of volunteering their time, which is really awesome. And it was a really great program. We're also, right now, we're doing bankruptcy cases due to COVID, eviction moratorium cases. So we're trying to do a lot of things to help the public. And the wonderful thing about this is a lot of our mediators and arbitrators agree to serve and do these either pro bono or for a minimal fee, because normally they're making maybe $650, $800 an hour. Then we drop it down to $350, negotiating with the state, which is great. And recently, the Small Claims Court of New York contacted us in the Southern District of New York, and they didn't hire us, but they asked us to reach out to our mediators and see what our mediators across the country, okay, and this is for New York cases, would agree to do these mediations, mandatory mediations. And there's a ton of our mediators agreed to do it for free, pro bono, which is really nice. Okay, so now moving on to COVID. When COVID hit in mid-March, the AAA, I'm really proud of the AAA, and also JAMS, CPR, FINRA, we were able, all of us, the institutions, to mobilize so quickly, and we did. And within 1 week, we have 600 employees at AAA. Okay, we were able to mobilize our company remote. 90% of us went remote. Again, I mentioned 26 offices, 18 states, in Singapore. It was, I couldn't believe it. I thought it would take a month to do that. And we never shut down. JAMS never shut down. CPR didn't shut down. The courts had to shut down, and I get that. I mean, I understand that. They're government institutions. We didn't shut down. We had the luxury of not being able to shut down. And within a short period of time, our arbitrators and mediators really embraced the virtual world. I was concerned. I thought there would be a generational gap. I mean, with me and other people, I didn't do a ton of Zoom calls like we're doing now. Now I do about, I would say, about 20 a day. So I wasn't that savvy with the technology, but it was surprising. Out of our, we have, like I mentioned, a lot of arbitrators on our panel, 6,000, and it wasn't a problem. Okay, and it was really kind of neat that they didn't have a problem with it. And my son's school is weird. People are worried about all the Zoom bombing. Okay, and my son's school, he's a senior at a school up the road from my house, and they were having Zoom bombing problems, okay, with the virtual stuff. And we didn't have any. And GMs didn't either. I talked to them. I talked to CPR. We're all friends, if you guys know that. We're competitors, but we're all friends. And we didn't have Zoom bombing because, know why? It's not the technology. It's the individuals. It's the settings and all that kind of stuff. So what we did, AAA, GMs, CPR, FINRA, ICC, we all developed guidelines. And if you go on all of our web pages, you go on AAA webpage, you can see some terrific guidelines on these protocols, okay? And the protocols are terrific, okay? And we have one with respect to Zoom specifically on doing settings, okay? And that has helped tremendously. And with respect to my son's school, what I did was I sent those Zoom settings to the school, and I said, listen, you're having some major Zoom problems. They have not had one Zoom bombing since, okay? Because again, it's not AAA, it's settings, it's doing the right thing with these things. So we've been pretty darn comfortable with this technology, and we've been doing a lot of them. Okay, we've done over 1,000 Zoom hearings since the pandemic, and initially people were worried. People were concerned and saying, well, let's wait until the pandemic ends. Let's wait a few months, and now, like I said, we've done over 1,000, okay? And our arbitrators are embracing it, which is really great, okay? And we even had, which is kind of cool, and I know we have some judges on this call, we don't want to, take cases from the court system, but we want to be there to help. And with respect to bankruptcy cases, we approached a federal judge in a bankruptcy court that we knew said that she was, overwhelmed. They just got back a couple months ago, and they were shut down. We were not shut down, and the court systems are limited, unfortunately, to one system, one virtual platform. The institutions are not. We can do any platform, and we do multiple platforms. So I talked to this judge, and we said, listen, we can do this bankruptcy case, a very big case, over $1 billion. And they agreed to work with us. And they said, well, can you do it by the end of the year? And my response was, I can do it next week. I mean, we have a great amount of panelists that can do this, that want to do this. So we did. We did it a couple of weeks ago with 2 co-mediators, one former bankruptcy judge and one mediator from Texas. And it was done over a 5-day period, 6 parties, 41 participants. So a lot of moving around in rooms, but it worked. It was so effective. So we love the technology. It seems to be working. But what I'm concerned about, and I mentioned this, if you were joined in early, you might have heard me talking to Alon about the future of this. Okay, with respect to hybrid, I think what's going to happen now is when we start to come back, and I was back this week. I'm at my home right now, but I was in my office earlier today. We had our first hybrid arbitration, okay, at my office. The only office out of our 26 offices to do the first hybrid since March, middle of March. And it was the arbitrator and some other people, and everyone else was zoomed in, and we did it at my office. So we're concerned about some of the really big cases, and what we're doing at our office in Midtown and elsewhere, LA and some other places. We're putting cameras in the ceilings, voice-activated cameras where they can focus in on a person, and it'll be kind of like Zoom, because we think this technology is pretty darn good, and we're hearing from a lot of our mediators and arbitrators that they can see the veracity of the witness. They can see the person sweating better than in the room sometimes. If they're 3 or 4 seats away from the witness, sometimes they can't read that. Now with Zoom, they can. So our concern right now is hybrid. Okay, and trying to figure that out, and we are. I mean, I've had many meetings at AAA, and I know JAMS has, CPR, and the other institutions are doing the same thing, trying to figure out how to reconfigure our rooms so we can have a hybrid hearing. And I get it. A lot of our arbitrators don't want to go back until there's a vaccine. Okay, and I understand that. And it's but the arbitrators are embracing the virtual world far more than counsel for clients. And it seems like the parties are now, the counsel for parties are struggling with this. And until they do it, until they try it out, then they see it's not that bad. And we had a couple of major law firms in New York City that were fighting it. But then when they ended up doing it, they were like, wow, this is not bad. I mean, it actually is effective and you can actually do it. And according to our rules, GM's rules, CPR rules, an arbitrator can rule to say, we're going to go virtual, even if both parties don't want to go virtual. And I mean, it's very interesting. And I've had several cases where this has happened, where both parties don't want to go virtual, but the arbitrator or arbitrators have ruled to go virtual. So, I mean, it's in our rules. So what is it in the future? I think in-person hearings are still going to happen, but what we have now in the, we call it the toolkit of the arbitrators and the mediators, is this virtual stuff. We had it 10 years ago, and the technology wasn't as good as it is now. It really wasn't, but it was pretty darn good, but we weren't using it. Now I see our arbitrators all the time now at AAA, and our mediators, when they do a prelim conference, they're all using Zoom. They never did in the past. They always just did it by phone. And we're doing Zoom. And at AAA, and I know JAMS does this too, and I think CPR does too, we have Zoom experts and virtual experts at our company to help out the arbitrators and the mediators. But they don't need much help, because all of you know on this call right now, it's not that difficult. It's pretty intuitive. It's pretty easy to use. So we hope that a lot of our arbitrators are embracing it, and they seem to be. But I think going forward, it's gonna be used. I think it's gonna be used a lot. And I think I was at a law school today talking, and one of the questions was, well, how much is it going to be used in the future? And I go, well, I think what's going to happen is people that were doing international arbitrations, clients are going to say, wow, during the pandemic, and now we're into 7 months, we're going to probably go another 7 months, who knows? They're saying, wow, I saved a lot of money. I saved a ton of money. They're going to say this to the attorneys. Why are we going in person now? Why are we flying to New York? Why are we flying to LA? Why don't we just do it virtual? Also, I think, and I was talking to India Johnson, our president, about this the other day, is when we get back to normal, when there's a winter storm, when someone's sick or whatever, it's not going to be unusual or strange for someone to suggest, let's go virtual. In the past, it would have been. I would have scratched my head, like, really? Or, come on. I mean, but now it's kind of there. Everyone is getting used to it, which is good. And again, we've done, over 1,000 cases virtual. And I know the other institutions have done the same. And now the court systems are, up and running, and they're doing it a lot too, which is terrific. So that's my little issue. I mean, that's my little summary of the AAA, and also about what we've been doing since COVID. So unless I have any questions, I'm going to turn to the next question. Elon, so I look to see if there's any questions before I turn to the next question.
I haven't got anything in the chat yet, so I think you've gone to the next thing. Just wanted to very quickly point out a lot of the efficiencies, Jeff, that you were discussing before. There's a great article by Sidney Kanazawa, who's a mediator. He wrote for Law 360, and he goes into a lot of depth that I just sent it around to everybody. So that's just an additional point. But I don't see anything else in the chat, so go on to the next question.
Great. The next question is your knowledge of arbitration opportunities in the New York area, useful for building arbitration experience. I'll even include mediation experience, because one of the big programs that we did, and I mentioned it already, was Storm Sandy back in 2013, Katrina down south. And that's where AAA, we enlist people. And I remember in 2013, my role at AAA, being the head of the commercial division in New York, was to enlist people, to enlist mediators. And I enlisted 200 people. They didn't end up on our, not all of them ended up on our panel, but we did enlist them, and they were signed up to our panel initially, and they handled these cases. And like I said, we did 6,000 Storm Sandy cases. Down south, we did Katrina cases. So when these things happen, unfortunately, obviously we don't want these bad things to happen, okay, but they're going to. And look at what we're going through right now. But when they happen, AAA does mass claims. So just remember that and contact AAA when there's a mass claim kind of a situation. If you're not already on our panel, we are looking for people. I mean, I remember I was part of the ADR committee of the New York City Bar, and my whole committee signed up. And I was really grateful that they did. So, you know, we're going to have these situations in the future. And, you know, if you want, and that's a good way to potentially get on AAA's panel. What we do is we sign you up for these programs, these mass claim programs, and then potentially you will maybe get on AAA's panel if we need somebody in your certain area. Also, I want to mention FINRA. If you're not already on FINRA panel, FINRA is always looking for panelists, and we have a number of people that are on AAA's panel that are on FINRA's panel. They have a pretty robust application process, and I'm not, you know, probably there's somebody, probably a number of people in this group that are on FINRA's panel. They have a robust, you know, application process, but they're a great organization, and I would consider using them. AAA also right now is doing civil commotion, you know, the civil unrest cases. We're doing those, and we enlisted a number of people, not a lot, because we think what happened in New York is probably, we're looking at about 500 cases. But when civil unrest happened in New York, you know, the state of New York contacted us and wanted us to handle those cases. And a lot of people say, well, are those cases against the people that are looting or, no, it's the insurance company versus the insured. and that's what those cases are, sort of like Storm Sandy. So we have that program up and running right now. And so if people have expertise in that area, please, you know, contact AAA. I mean, these are mass claims that we do. Also, and I mentioned this, the small claims court, contact them. If you're interested in doing mediations, okay, these are mediations, not arbitrations. They have a mandatory mediation program, and they reached out to AAA, and I reached out to all of our mediators across the country, and I had a lot of people that volunteered, and that helps. That really, really does help with your resume, and people look at that. And I, like I mentioned, Storm Sandy, I have a lot of people that jumped on our panel for Storm Sandy and then eventually got on our mediation panel or our AAA's arbitration panel, because they helped us out a lot. And I know we have people here that have done a lot of Storm Sandy. I mean, some people have done like 40 Storm Sandy cases. Also, I want to mention, it's a plug, for AAAmediation.org, AAAmediation.org. Okay, and that's a website. It's also a think tank. It's part of AAA. And it's a website that you can, if you're not on the AAA's panel, you can sign up for that. It's a really minimal fee. I forget what it is, but I know it's under $300 or $400, where you can sign up, have your photo there, your background, and it'll say you're not affiliated with AAA yet, but you're part, you know, you're part of AAAmediation.org, and that site has hit a lot. People go there, and we give you the metrics. So if you're, you know, if you want to go on that site, I would take a look at it. And we get a lot of people that, you know, may not eventually be on AAA's site. I'll give you an example, like people that do divorce law, that kind of stuff, or divorce mediators. We don't do that at AAA, but they end up on our AAAmediation.org site because they feel like they can get some good, you know, promotion there. And we do, we promote it. So take a look at that. It's kind of a neat site, okay? So I'll move on to the final question. I'll look and see if there's any questions here. Okay. I don't see any. Okay, so I'll move on.
Jeff, hang on. We're about to get another one from Angelina Serrano. She just sent me this one privately, and I just relayed it. What, if any, requirements are there to get on the AAA panel? And what, if any, arbitration opportunities are there for bilingual arbitrators?
Oh, okay. Great question. And that's my next thing that I was going into. This is the question, so I'll put this on top of it. The steps for joining the AAA's arbitration and mediation panel rosters and mediation of neutrals, as well as what AAA is looking for in prospective arbitrators and mediators. Okay, so that's kind of what you're asking. We have, in 1990, we had 56,000 people on our panel. 56,000, not, you know, 5,600, 56,000. So when I started at AAA, we had that many. In the 90s, we did a major purge and weeded down our panel to 6,000. And that's what we currently have, 6,000, which is pretty massive in comparison to our competitors. I think JAMS has about 350. We have 6,000, okay? Because we do, we're pretty big. We do a lot of cases around the country. Okay, so in the 1990s, it was more like a membership thing, and we got away from that. So we made certain requirements. So now to get on the AAA's panel, it varies by the area of law. But most areas, my area, I do commercial. and I could talk about the other areas too. My area, you need a minimum of 15 years of experience in your area of practice, okay? And mostly in my area of commercial, it's lawyers. You have to be a lawyer, okay? I would say 98% of my panel in commercial are lawyers. You look at construction, that number drops down probably to about 90%, okay? Because you have engineers and architects, okay? So you have to have 15 years, okay? And the question we ask is, we need, are you well known in the community? And unlike some of our competitors, we don't require that you have arbitration experience as an arbitrator. We just want to know that you have experience as an advocate. I don't want people applying to our panel, our commercial panel, and I'm just talking about our commercial panel, I'll move to our employment panel, our labor panel. I don't want them applying if they have no arbitration experience. And when I say no arbitration or mediation experience, that means they've never done an arbitration or mediation as an advocate. Now, I have plenty of people that apply to our panel, that get on our panel that have tons and tons of experience as an advocate. And they're great. I mean, those are the kind of people we want. They've taken some training courses through the New York State Bar, through other organizations, and we don't actually train people to be arbitrators. Once you get on our panel, accept it, we do a 2-day training. And it's not training to be an arbitrator, it's just basically saying these are our expectations, we're going to help you with your resume, and we kind of have a dialogue with the new arbitrator. But we're looking for people that have a lot of industry experience. And like I said, I've been at the company for 30 years. And when I first started off at AAA, we would take people that had general experience, general practitioner. What we're looking for now is people that have a lot of industry experience as a lawyer, okay, in certain areas, insurance, healthcare, because that's what our clients are asking for. And we're seeing that. And what I do, my team in Midtown Manhattan, we do the high-end cases, the 5 million and up, and we get on calls with the clients, and before we even appoint an arbitrator, we spend time with them and ask them, what do you want? What are you looking for? And they go into details, and that wasn't true in the past. And they're looking for specific things. And so, to answer that question, and to answer the question that was posed to me, before this program, 15 years, people that have a lot of experience in certain areas, and you're known in the community. I don't want to create expectations, and I don't want to put someone on the panel that, we put you on the panel and, nobody knows who you are, okay, in the community. And that's important. And we look at that. And what we do in New York for the New York panel is we usually meet with the person directly. My colleague, Monzi Carroll, who is my director of ADR services, we'll meet for coffee. We used to, pre-pandemic. Now we do it virtual. We do a virtual coffee. And we only let on our panel probably about, I would say, anywhere between 8 to 10 people a year now. And we have, in New York, we have a panel of 400 people. So it's a very, very, very competitive market. And, we only, we're looking at people that we need. So sometimes people apply and they're terrific. They have so much healthcare expertise. And then I look at our panel and I say, well, we already have a certain percentage of people that already cover that area. So let's hold off on this person for now and have him or her apply a little bit later on. So when we get an application, I get probably, honestly, 2 to 3 a week. Okay, that's it. 2 to 3 a week. People are trying to apply to AAA's panel, and my colleague and I will look at it. We'll talk to our panel relations team in Dallas, and we'll say, okay, does New York need another person in this area of law? Does this person meet the requirements? And also, we're obviously very sensitive about diversity. And like I mentioned at the beginning, our panel is 26% diverse. And that's an important thing that we take into consideration also. But it's more, it really is more, does the person have the qualifications that we're looking for in certain areas of law? For example, financial services became a big area for my company about a year ago. Our caseload increased by 50 or 70% over a 1-year period. So we were looking for people. We never recruit, and I'll tell you that, we don't recruit. Some organizations, I think, recruit. We don't. What we do is we just look at the applicants that are coming in, and trust me, we can find someone that meets that expertise. So that's pretty important. So, if you're considering applying to AAA, look at your background, see, if you have the certain expertise. And I always say, are you pretty well known in the community? Because we don't want to start listing somebody that is not. Now, for employment, and I mentioned that was commercial, for employment and labor, for the folks that are here today that do employment and labor, it's different. For labor, unfortunately, and it's kind of interesting, you cannot be working for a union or management, or be representing union or management in a firm. You have to be you have to be neutral, and so it eliminates a lot of really good candidates. And we're hoping someday that it changes, but that's what the National Academy of Arbitrators wants. That's what a lot of people are saying. That's a good thing. I don't necessarily agree with that. But right now, you have to be a neutral. So you cannot apply for AAA's panel to be on our labor panel unless you're neutral. You're not working for a union firm or a management firm. Employment, and then this makes it a little bit challenging too. And I have a lot of great people that could potentially be on our employment panel, but they have to have 50% or around 50% of experience in employment matters as a general counsel or as an in-house or as a lawyer. So that's a hurdle for some people. So those are some higher standards that they have to apply for. So I mean, just consider that if you're in the labor and employment area. And again, it's a competitive market. Our market is so competitive, which I love. I mean, I think I have, and I brag about this to my fellow colleagues at AAA. Don't tell them I said this, but I have the best arbitrators and mediators in the country. I really do. I mean, New York is stellar. It really is. And even when I was in labor and employment, now I'm in commercial, we have a phenomenal, the best, the brightest, the best, and it's competitive. I mean, my God. I mean, I have 400 people on my panel just in New York. My district is New York only. And my colleagues in international, they represent the world and they have 600 people on their panel. So that just tells you a little bit about the New York market, how ADR friendly it is, but competitive. And so if you get on a panel, you get on a FINRA panel or a AAA panel, CPR, don't be discouraged if it takes a little time to get some cases. And I tell that to all of our new arbitrators. It's not a it's not a sprint, it's a marathon, and just take your time and we try to help you out, and we do. But again, we're pretty selective. I mean, right now, I mean, we weren't in the 90s, and we became very, very selective because when I started off at the AAA, when I generated a list, I hated to hear a client call me up and saying, why the heck did you put this person on this list? He or she doesn't have these qualifications. So these are the things that we really, really focus on now. And you got to think about that too, as a arbitrator or mediator, about your resume, your social media presence, all that kind of stuff. It's being looked at big time now, and we do. Even though, let's say if you're on the AAA's panel as an arbitrator or a mediator, when I sit down with my team to generate a list of 15 for a big case or 10 for a smaller case, we meet and we go beyond the resume that we have at the AAA. We look on social media. We look on your LinkedIn page. We look on your web pages, and we see, do you meet these qualifications for this case? We take it seriously because know why? The clients are taking it seriously, and we hear it. The calls that I mentioned, that when I get on a call with some of our clients, it sometimes is a 30-minute to an hour call about what are the qualifications of this arbitrator and mediator that we want in this case. Then I get off the call, I meet with my team in Manhattan, and we sit down and we talk about who would be the best person for this case, and then we generate the list. So that's I mean, I'm sorry, it's a long-winded thing explaining how you get on the AAA panel, but it's difficult. It's a challenging, but again, we accept in New York about 8 to 10 people a year, and you have to have certain requirements, and it's online. If you can go on our webpage, you'll see. I mentioned a couple of the things that AAA requires, but there's a lot of things there. There's other things there that we require too. But the one cool thing that we don't require is that you have arbitrated a case as an arbitrator or mediated a case as a mediator. So just remember that that's kind of a difference, I think, that AAA is. So Elon, do I have more time, or do you want me to look to the question?
Yeah, you have a ton of more time. Let's just take a break just to recap some of the stuff I think you mentioned before. We can amplify with some of the questions. So I want to go back to 2 questions from Janice Sparrow, who is actually an arbitrator from California. So now we're trans-coast as well. Thank you, Janice. Her first question is, what's the attrition rate? I think she meant that generally with respect to the panels.
I don't know. I really don't know. It's a great question, and that's something I'll have to get back to you about. I don't have the stats on that, and I would hate to just go off the top of my head and say, oh, here's the attrition rate. I don't know right at this point. Yeah, but that's a good question. But I can get back to the group, and Elon, I can email you. We have a stats department actually at AAA that keeps the stats and all that kind of stuff, and that's one area that I don't know. But I can get back to you on that.
Okay, so that's certainly to follow up on. And then also her other question was, given the pandemic and Zoom, why are hearings, I guess, still slated regionally?
They're not. They're not. And that's a great question, because I've been saying now to my team in Manhattan only does the high-end cases. And what we say to clients now is, when we get on a call with them before the arbitrators are appointed, we say, do you realize that we may not be going to in-person hearings in the near future? And therefore, would you accept virtual hearings? And they say, sure, both sides say it. And then I say, okay, in light of that, would you accept me to generate a panel, not generate a panel, generate a list of arbitrators that are expertise, or have the expertise that you need throughout the country, throughout the world? And they're saying yes, which is great. And so what I've been doing, a couple of my cases recently, really big high-end cases, we've been doing that. We've been saying, okay, we're going to get people from around the country. And I've been telling new arbitrators that get on our panel, now you have an opportunity. Now you have an opportunity. You're not just limited to, like some people, like New York's a great area. I mean, there's so many cases, but arbitrators that are in the South and certain areas of the country, it's not a lot of cases. Okay, there's not like it is in New York. And so now they have an opportunity to do New York cases. But to answer your question, we're not limiting, and we're asking the clients, do you want to go beyond? Like normally I'll generate a list of just New York region, that's it. Connecticut, New York, New Jersey, and that's it. Now I'm going beyond it. I really am.
Okay, great answer then. It's always good to see the expansion. We have 2 questions I'm going to dovetail together, because even though they're from different levels of experience, they are sort of related with respect to experience. So the first one is from Joanna Conzior. Does the AAA panel offer, I guess the AAA, I don't know if the individual panels do, but maybe they do. Does AAA offer internships for law students? That's the first question. And the related one from Frank Procia is, I just finished BMT mediation training with New York Peace Institute and plan to do their apprenticeship. Is there another good way to get experience as a new mediator, which the implication there would be a mediation internship? So does AAA offer arbitration and or mediation internships or apprenticeship?
We offer internships usually through ICDR has some, the international division of our branch offers internships. Our marketing department does, various departments do, but it just depends on what they need. My commercial division hasn't had an internship for a while, but we do. We do, and most of them, some of them are paid, some of them are unpaid. We had an intern at our office for about a year in my Midtown office, where what she was doing was reviewing awards and seeing trends in various international awards. So we do. I mean, and yeah, please, apply. You can send me your resume. I'll put my email on here. And what I'll do is I send it to, usually when I get these, I get these requests every week or every couple of weeks. I send it to our human resources department, and they store it in a certain database for when a department, a division needs an intern. But yes, to answer your question, we definitely do. With respect to the mediation question, was that an intern as shadowing a mediator? Was that
I think it was more like an apprenticeship also. It would fall into that category for him.
I mean, what we do at AAA is if someone wants to do that, usually it has to be someone that's already on our panel. That's new to our panel. We'll say, okay, we'll hook you up with someone that can be your mentor. You'll be the mentee. We don't usually take general calls from the public. We have the Higginbotham program for diverse people, which we do every other year. And we have a diversity program where we have a mentorship program there. But, that said, you could call, the local office, my office, and say, hey, listen, I would love to see a mediation, love to see an arbitration. We try to help you. We do that all the time. It's not that difficult. The only problem is getting the parties to agree to allow you in the room. That's the only problem. But and I've had some problems, especially with some controversy, some high-profile cases. They don't want somebody in the room, and you have to sign various confidentiality agreements. But we do. But it's more for people that are already on our panel, that are new to our panel, and also the Higginbotham program.
Just a reminder from Cynthia Boyce. She actually pointed me to a question she asked earlier. I just want to go back to this. So you were talking about mass claims and bringing your arbitrators sort of ad hoc in for that. Her question is, how do we learn when you are doing mass claims so that we can sign up?
Good question. Look at our webpage. Monitor our webpage, because we're really good about telling the public about what we're doing. And you'll see, if you go on our webpage tonight, adr.org, you'll see our bankruptcy program. You'll see our the eviction program. You'll see that in our banners. And if you see that something in one of our banners, our sliding banners, call us. Call me or email me. And that's what happened during Storm Sandy. When Storm Sandy happened, we had a banner ad about needing individuals that could do these kind of claims at a reduced rate. And again, I recruited about 200 people, and it was not hard. It was really quite simple to do that, and they were great. They really were great, and like I said, a good percentage of them ended up on our panel because we saw that they were really terrific in handling these cases. But just monitor our webpage. We don't, and look at what the state's doing. Usually these programs come from the federal government or the state, and we're hired AAA. I'm proud of this because we're a not-for-profit, and they know that we're not-for-profit, and we'll do a great job. And we've done a lot of these mass claims over 30, 40 years. So yeah, definitely monitor our webpage.
Okay, thank you very much. We have two quick questions of clarification. I'm just going to join them up with Lisa Askenazi, since she basically, I think it also dovetails with Cheryl Anstasto's question. Do you say that AAA takes divorce and family mediations, or no? And I believe Cheryl Ann had a similar question as well.
Yeah, we don't. And actually, when I started at AAA, we had family law mediation rules. And I remember seeing those, and I was like, wow, this is interesting. And we don't. It's kind of a difficult area for us to get involved in. But are we considering it? And I've been talked to by a lot of people in the ABA, New York State Bar Association, New York City Bar Association, saying, you guys really vet your mediators, and you guys would be a great organization to vet people for a panel to do these kind of cases, because a lot of people are just hanging their shingle and saying they can do divorce mediations, and they're really not qualified. And so our response to that is we do mediation training, but we don't handle the cases. But have we looked into it? Have we continued to? Yeah, we are. But right now, no, we don't touch family law. And some of my colleagues are happy that we don't want people running around the hallways crying and all this kind of stuff. But we do see that. We do see business divorces, and we see people yelling at each other and stuff like that in our hallways. But no, we don't. But we might in the future. We might. But mediation, obviously, for family stuff.
Okay. Thank you very much. We also have another quick question of clarification from Diane O'Connell. If you are a AAA arbitrator, can you just join the mediation roster?
Yes. If you're a AAA arbitrator, can you join the mediation panel?
Yeah, in other words, once you have standing as a AAA panelist, do you get automatically grandfathered into a mediation roster?
No, unless you take training. You have to do, we require that you do the 40-hour training, like the state. The state requires that, the state of New York, other states require that for you to get on their roster. We require a 40-hour training. and then we require that you have some mediation experience as an advocate or as a mediator. And it's completely different skills sets, as everyone probably knows. And a lot of arbitrators don't make great mediators, but we have a lot of our arbitrators that are both arbitrators and mediators. Yeah, I would say about 30% of our roster in New York are both arbitrators and mediators, and they're darn good at both. But yeah, again, you have to take that training, and it doesn't have to be through AAA. We provide it, and we're not like seeking people to take our training courses. You can take it through the New York State Bar Association, New York City Bar. There's so many programs, ABA. But yeah, you have to take the 40-hour training and then contact AAA if you're already on it.
And just so that when you say the 40-hour training, just for the people who've done it before, do you mean the 40-hour, 24 basic and 16 and specialized, or do you? Okay, yeah,
Yep,
it's basically the equivalent of Part 146, is whatever the Part 146 requirements.
Exactly.
Okay. Yeah. So for everybody who's was interested in that, if you fulfill your Part 146 requirements, you've fulfilled that as well. So the people who are asking about divorce mediation, what else? Your 16 hours and your specialization will count for that. Okay. We have another question here from Angelina Serrano. Can you explain what you meant by labor employment arbitration need 50% experience in labor and employment? And another question, how many years do labor and employment arbitrators need as advocates in labor and employment to be considered for the panel? 15 years?
Good question. Okay. Actually, commercial's different. Commercial's 15 years, labor and employment's 10. But again, labor and employment, you got to separate them. Okay. So labor, you have to be neutral. You can't be working for a union firm or a management firm. You have to be independent. Okay. And that's when you apply. So that's kind of hard. And we see that with people that, a lot of the people that apply to our panel have a significant other that can support them when they're doing this, career change. They're not working for a labor or a management firm, and they have to do that. So that's labor. That's a separate area. It's 10, it's 10 years, and you have to get references from 3 management, 3 union, and 3 labor arbitrators. Okay, so you need those 9 references. So it's that's not that difficult. But I mean, a lot if you're in the area of labor. Employment is different animal. You have to have 50% experience as in your law firm doing employment stuff, or in-house counsel doing employment stuff. Do we hold you at that 50%? Not necessarily. I mean, if you had, let's say, 40% and you're a stellar candidate, we're going to accept you. But our we say online at AAA is 50%, and it's a 10-year experience. It's not the 15 years that we require in commercial.
Okay. Some additional follow-up from Ariel Boverman on employment. Do you need a law degree to do employment?
Yes. Not labor, but employment, yes. Good question. Good question.
And then now switching gears a little bit, I don't know if you maybe want to take this after the next segment, but as far as I can see, the last question that we have, I think we're all caught up now, is from Spence Packer. What are the requirements to become a New York no-fault insurance arbitrator?
Great question. It's not up to me or AAA. And a lot of people don't know this, that we do a big part of our caseload is the no-fault stuff. It's huge in New York. I mean, we're doing about 200,000 cases of no-fault in New York. So when I say that 300,000 number, a lot of it's no-fault insurance in New York. And they've been our client for 30 years. That's the state of New York. They select the people. Okay, so what it is I don't know what the requirements are, but you have to go through the state of New York, okay? And AAA is a member of the panel that sits there and reviews the applicants, but we have no vote, okay? It's only the state of New York that votes and decides who's gonna be on that panel, our panel, okay? And once they get on our panel, we provide them with a laptop, we provide them with a scheduling system, all that stuff. We're their case manager in a sense, but we have nothing to do with respect to selecting those candidates. That's something that the New York State does. So you might want to the Department of Financial Services. You might want to go onto their webpage and that's the group that hired AAA, and look at what their requirements are. I think they're there, but again, we have no vote on that. We're just a client of the state of New York for those cases.
And with that, I believe we are all caught up. So Jeff, if you want to go to your next question to start off your next speaking segment, go right ahead.
I don't have, I have those 3 questions, but I do want to mention, here's what I mentioned, which I think the crowd might find interesting, and I've talked about this with other groups. Has anyone heard of the JZ case, JZ arbitration case? Raise your hand if you have. Okay, so that was my case, and you know, I say this all the time. I'm the original JZ. You know, I was born before he was, but I want to mention that case because they got it. The media got it wrong. And when I say that is that case, I'm not sure if you don't know about it. Jay-Z, the rapper, the case was filed against him. A Connex brand, his former brand, filed a case against Jay-Z for trademark issues. And it was a AAA arbitration case. And we put together a list. The list was 50% or more diverse. Okay. And the firm came back and said, and I could talk about this because it went to court. The firm came back and said, well, yeah, it's 50% diverse or more, but we want an African-American male in this case. Okay, and so that was interesting for AAA to encounter this. So, you know, our position was, well, okay, you know, what does the other side want? It's the party's process. They ended up filing for a temporary restraining order against AAA, or not, against us proceeding, and it was granted. And the reason it was granted wasn't because the court system believed in their argument. It was granted because the court system, the judge that was assigned the case, his wife passed away. And there was another judge assigned to this case, and she you know, took on the case and granted the TRO because she just wanted to wait until he got back. But when she granted the TRO, she kind of, this is all on the record, she, you know, kind of said, I can't believe this argument. And you're saying that I can't, as a white female, hear this case. So she made that argument, and that's on the record. But anyways, the TRO was granted. Then the media took this and ran with it and got it wrong. And I don't like to quote, you know, our president, but it was fake news. It was definitely fake news at that time. And we were like, oh my God. I mean, you know, the TRO was only granted because of the judge's wife passing away, and AAA has done a lot for diversity, and we were kind of upset about it, and I have too, in New York especially. And we were kind of annoyed by the fact that you know, people were saying in the media that AAA you know, is not diverse in our panel, and yeah, we have a long way to go. I mean, we're, as I mentioned, 25% diverse, but we're trying. I mean, it's a societal issue. It's not a AAA, JAMS, CPR, FINRA issue. It's a societal issue, law school issue, people going to law school. And that case ended up settling, you know, thank God. But, you know, it hit the press, and the press got it wrong. And it really annoyed me. And it really annoyed me when my 20-year-old son, you know, texted me and said, Dad, what's going on? You know, the AAA doesn't have any African-American males on your panel. I'm like, no, we have plenty. We have, you know, a lot. Do we want more? Absolutely. So that was a really interesting case. I would, you know, look that up if you're interested in that. But we do at AAA really care about that issue. And our panel, like I mentioned, is 25% diverse. And what we do now on all of our lists that go out since, I think, 2013 and 2014, has to be 20% diverse. And in 2019, we met that. We had 98% of our cases that went out were 20% diverse, if not more. So that was an interesting, really interesting case, you know, that we came across at AAA. A really interesting case.
Actually, there's a follow-up question directly on that point from Cynthia, and we'll get back to you, Anthony. I see your question as well, but this is directly on topic, so now we're going to go to that first. How does AAA define diverse? And I'll just say, from my perspective as an Orthodox Jew, does that definition include religion as well as racial or ethnic characteristics?
Great question, because I get asked that all the time. And I was asked that on a case recently, where, just recently, a month ago, race and gender, you know, and right now that's it. Okay, race and gender. And I even had a client say to me, well, really, gender? We thought it should just only be race. And this year we're looking into LGBTQ, qualification too. We're considering that, and we're going to probably do that. But right now it's just race and gender at AAA. And there's been some issues about that. And since the Jay-Z case, I've had cases that I know of that I'm actually handling where the clients have come to us and said, one client, we want all African-American males, we want all Asian-American females, or we want all females. And my position on that, and AAA's position, is sure, we'll do that. If you want that, we have that on our panel, but does the other side agree? So if the other side doesn't agree, we can't do that. Okay, so because that's just not fair. So we'll give you we'll make sure the list is diverse. So we're seeing that. That's the Jay-Z effect. We're seeing that right now, and I get it. But is that fair to the other side? You got to say, you got to talk to the other side. So this one case I had was really worked out well, where one side wanted, like the Jay-Z case, and they quoted the Jay-Z case, an African-American male to hear this case. It involved an African-American male executive in a major company, a very wealthy man, and he wanted that type of person to hear the case. And we had a call with the other side, and they ended up agreeing to put together, each side put together their own list, gave it to AAA. I put together a diverse list too, a mixture of qualified people, and we came up with somebody. So we're trying to address that issue, but my answer always is, if both sides agree, if you want a bald white male like me, you'll get it. But if both sides agree on that, but otherwise you're going to get a diverse list that we think are people that are qualified to hear this case.
Great response. Thank you so much. I'm going to go back now to Anthony because I promised I was going to do so. I always like to keep my word. So he writes, "Hi, great presentation. I'm an avid mediator in Colorado, not a lawyer, and not too interested in getting into arbitration. What opportunities are there for me with AAA for a non-lawyer?"
Sure. Non-lawyer? Is he a non-lawyer, you said?
Yes, not a lawyer.
Okay, non-lawyer. Okay. I mean, I think, there are opportunities in mediation or arbitration also for non-lawyers. If you have a specific field, like I mentioned earlier, like architects, engineers, accountants, if you have some specific area that you're really experienced, but not so much in mediation. If you're a darn good mediator and people know that in the community, great. I mean, that's wonderful. So there are opportunities for non-attorneys, but again, the majority of our people on our panel are attorneys, both mediation and arbitration, because guess what? The people that are selecting you guys are attorneys. And so they're looking for someone that has a legal background to some extent. But again, we have cases like Storm Sandy. Don't necessarily involve a lot of legal issues. We have other caseloads that involve construction and all that kind of stuff, where do you really want a lawyer? Wouldn't you want an architect or an engineer or a specific field? So, I mean, there are opportunities, but it's not huge opportunities. But for Colorado, I would suggest contacting my good colleague, Lance Tanaka, who is the equivalent of me, but in Colorado. Lance Tanaka is his name.
Okay, thank you for that information. And actually, we now have a request for additional information. Can you please send the link for the applications requirements for the mediation panels? And Cynthia, that's from Holly, and Cynthia also asks, what are the requirements to join the mediation panels?
Great question, and I don't have to send it because all you have to do is go on to adr.org, our webpage, and you'll see there's up on the top, you just go qualifications for AAA's panel, and there's a nice PDF you can download of the qualifications for mediators and for arbitrators. It's all there. And if you can't find it, email me. But it is there. It's on our webpage, our qualifications for mediators and arbitrators.
I just put that in the chat. It's www.adr.org. So you can go there and download and find the documents that you would have. Okay. There was, I think, one other. No, we got to that. Okay. So then I'm going to actually just ask you a question that I had, and I'm just not going to take the time to put it out. what percentage of cases are decided by solo arbitrators? You can answer this across all the panels if you know. If not, just do it based on your commercial experience.
Sure.
What percentage of cases are decided by solo arbitrators? What percentage by 3 arbitrator panels? And have there been any other cases where you've gone beyond 3 arbitrators on a panel?
Great question. Okay, so the majority are decided by sole arbitrators because unless the contract states specifically for 3 arbitrators, we don't appoint 3 arbitrators to a case unless it's $500,000 and up. Okay, if let's say the contract is silent, we will go ahead and appoint 3 arbitrators. I think that number should go up. We're all New Yorkers on this call. I think $500,000 is not a lot of money. It's a lot of money to me personally, but not a lot of money for an arbitration. So I think, 3 arbitrators is kind of ridiculous. The number should go up, but we default automatically for that. Okay, so the majority of our cases are sole arbitrators. I try to convince people, even for the large cases that are multi-million dollars, to go with 1 arbitrator. And the reason I do is because I feel very confident about our panel, and I feel like you're not going to get a rogue arbitrator. And going with a single arbitrator saves you 5 times more financially. Okay, it saves the client 5 times more, and it takes about 6 months more with 3 arbitrators, just the scheduling and all that kind of stuff. But again, the majority of our cases, because we do 300,000 cases, and the commercial cases that I do, even that area, which is about 10,000 cases, I would say in that caseload, I would say about 70% are solo arbitrators and 30% are a tribunal. But I'll tell you this right now, arbitrators love to be on a tribunal. I mean, they do. I mean, they feel like it's a lonely profession when you're by yourself deciding a case, and you can't obviously do ex parte communication or even talk to the person in the elevator or whatever. They like to bounce things off their wing arbitrators. But AAA, anything above 500,000, we go with 3 if it's silent. But Elon, I think you had another question at the end of that one too.
Yeah, has there ever been a time when you've exceeded 3 arbitrators on a panel?
Oh, that's right. Okay, that's a great question too. We hate that, and we normally go with 1 or 3. And yes, in mostly insurance cases, reinsurance insurance cases, they have some really funky clauses that just drive us crazy. And sometimes they end up where if we do it, we'll end up having an even number. And if we have an even number, we can't do that because let's say with 3 vote one way, 3 vote the other way, what are we going to do? So our position, I've had those clauses where a board member can be on the panel, someone, then they can select someone. And I had a case recently where it called for it ended up being 6 people, 3 on each side. And our position was, this is crazy, okay? This clause was drafted by someone that doesn't know arbitration, and let's go with 3. And then they didn't want to, then I think with that case, we ended up going with 7. But it is it's not normal. It's not, it doesn't happen that often. I would say 1% of our cases end up with that, and we hate it. And it's just not a good way of doing arbitration, I don't think personally. But great question.
Right. All those people who want to act like they were part of the Supreme Court got to look elsewhere, I guess.
Exactly. Supreme Court packing or arbitration packing. But it's most, like I said, it's only 1% of those contract clauses. And speaking of that, we see some ridiculous clauses out there like that, and ridiculous clauses where they call for, specifics about the arbitrator. The person has to have 10 years of experience as an executive in a cosmetic firm or whatever. And we're like, oh my God, we have a lot of people on our panel, 6,000, but come on. Or they specifically mention a person. John Doe will be our arbitrator for this case. Well, then our position is, well, what if he passed away, or what if come on? It's silliness. So look up. I'm not plugging AAA. I'm plugging Drafting Good Clauses, Clause Builder. It's a program that we have online. It's free. It's called Clause Builder. It's our most hit site, and it's free again. And CPR has one similar to it. And you can draft a clause, okay, for arbitration, and it has a part in there about selecting arbitrators and how many arbitrators you should put on the list or in your contract.
Yeah, it's actually, I've experimented with that before. It's very, very useful. It's a nice engine also in terms of putting the clauses together. It's just, even if you don't have currently a pending case, I do recommend it to everybody. It's worthwhile just to go there and give it a run just to see how it works out. It's pretty sophisticated.
Especially from being an employee of the AAA, I used to be called, I mean, for so many years, I was called by counsel on so many cases, like I'm drafting a clause and I would sit there and send them templates and give them recommendations. Now all I say is, go to Clause Builder. it's all there. I was on the committee that formed it, and it's a great. It really is a great site. And again, you don't have to use AAA. You can cross off AAA and put in any other provider. I'm not promoting AAA. I'm promoting good clause drafting because I have cases, and Nelson knows this. But I mentioned this I think in his class. I have cases. A contract right now, 1961. The contract was drafted. It's a pending case at AAA, and it involves a well-known author that everyone on this call knows, everyone, and I can't mention, it's confidential, and movie rights and all that kind of stuff to a book. And in 1961 on a typewriter. And it's kind of neat. And it called for using AAA and it's actually a well-drafted clauses. These clauses last forever, they really do.
Yeah, nothing like an oldie and goodie at the same time. We have another question from Angelina Serrano. Does AAA conduct arbitration in languages other than English, and are there opportunities for bilingual arbitrators? Just for reaction.
Great question. Absolutely, we do, and we have an ICDR branch, the international branch, and yes, they do, in a number of languages. So many languages, and we even had in our Midtown office. This was really fought for when we were building out the space in 2013, a translation booth. And I was like, well, why do we need a translation booth? I'm in commercial domestic. And my international colleague said, Jeff, come on, we do. And we had. Do we use it a lot? No, I'd say maybe 6-7 times a year. But yes, we do. I mean, and we do arbitrations not just in the U.S. We do arbitrations around the world. And we do really look favorably upon candidates that have multiple languages skills. It really does help when you're applying for a panel, for our ICDR branch. And even for our domestic branch, I mean, for our domestic branch, mostly, the languages that we know in this country, Spanish primarily, that helps. It really does help.
Okay. I think we are caught up on the chat. I guess now we're going to do is I'm just going to open it up to the floor. If anybody has a question, you can unmute yourself, and Mr. Zaino is here for the asking over here. So go ahead and unmute. That's Alt-A, and ask away. Or if we exhausted all of the questions that we have, okay.
Well, I'll mention one thing. I mentioned earlier about the areas that were negative about arbitration, employment, and consumer. And I'm not sure if anybody on this call remembers, maybe you do or don't, the expose by the New York Times. They did a series on the Sunday Times about how bad arbitration is because of consumer and employment. We were interviewed at AAA for 4 hours, and it was a really negative article about arbitration because they were saying that's not fair, consumer, and like I mentioned earlier today, earlier tonight, that we have a due process protocol. For consumer and employment are trying to do the best we can. But with respect to those articles, they were written by people that didn't really understand arbitration. They really didn't understand arbitration, and it kind of was frustrating for us. And the kicker, here's the kicker, the New York Times has an employment arbitration clause for their employees. And they were criticizing, employment arbitration. So I was like, okay, we were like, yeah. But I mean, we wanted to defend ourselves on that, and my position was we really don't have to because it's all on our webpage. We have these due process protocols. I really do feel and strongly, and I don't want to sound dramatic, but we're the good guys. We're trying to level the playing fields, and I've heard from a lot of employees that come to arbitration. They were frustrated. They're nervous about it, rightly so, and some of them were not pro bono, didn't have a counsel. And they said, wow, I got my day in court. And another thing I mentioned earlier today was with respect to arbitration, which I love, the confidentiality and the privacy of it, and some people think that's negative. We had a well-known actress that everyone on this call would know. Everyone, without a doubt, at our office about 9 months ago. And she loved the fact that she could walk around our office in Midtown. And some of you have been to our Midtown office. No one bothered her. No one took a photo. No one did any of that because, we're the private sector. We're not going to do that. If a person was going into court, it may be a different situation. There'd be the press outside, there'd be all that kind of stuff. So that's kind of the cool thing about a lot of people that want to use arbitration and mediation because they don't want to deal with the public stuff that's going on. And we do a lot of high profile stuff, and it's kind of neat that they feel that comfortable with doing it with us.
Thank you for that perspective and for that information. That's always good to know. And yeah, I mean, as you see, also there's been a lot, especially in the tech sectors, as I've seen, Microsoft and other companies are putting in these clauses now, which effectively kill people's access to the courts. It's good to hear at least that you guys are taking that into consideration, and that's always been a concern, at least from the consumer side. So always good to hear. I do. I mean, again, if anybody wants to jump in, go right ahead. I do have one other question that I sort of had up my sleeve. To the extent that you've ever come across a situation where you have another arbitration provider who has to deal with a case first, either because you have a tiered clause, I shouldn't say even an arbitration provider, an ADR provider, because you have a tiered clause, such as you have to do mediation first with this provider, and then they can go through arbitration with AAA, or alternatively, because there's a religious component, let's say the Beth Dean of America, for cases, first parties have to try to bring their case there before they go to AAA. I don't know if you ever had a case like that before, but how do you deal with situations where you have to interact with another provider?
Well, like I mentioned, I'm good friends actually with several people from JAMS, CPR, FINRA. I do actually a lot of programs with them, and a lot of people don't know that they think, oh, you guys are competitors, you guys don't communicate. No, we communicate all the time because it's nice to be with people that actually know what we are going through, and I love it. I have a lot of good friends internally at JAMS, and also arbitrators, mediators that work for those institutions. But yes, we have had several cases like that where there's a step clause where it went to JAMS first, and then they're required to go to AAA afterwards. I have many cases with non-AAA arbitrators that are on my cases. AAA cases in New York where there's some JAMS people, some ICC people, but there's a lot of overlap. It's not a problem. At AAA, we accept that. We don't, say, at AAA, we say anybody can hear your case if both sides agree. If both sides are in agreement, anybody can hear your case. And we see some interesting things. I mean, there was a clause I saw recently where it was required to be, if the parties couldn't agree, it had to be the president of the New York City Bar Association, which we were like, oh, that's just crazy. Or it had to be the president of the AAA. And then the president of AAA, the president that I report to, India Johnson, called me up and said, I'm not doing this. I go, I know you're not doing this. I go, so we're going to have to talk to the parties. But the parties write various things into the clauses. We kind of talk to them. But with respect to the other institutions, we work great together. We really do. And since the pandemic, we've been really working together well with respect to doing programs and talking about the pandemic and how we're addressing it. And we're friends. And I love when I go to an in-person event and people come up to us like, oh my God, why are you hanging out with this JAMS person and this CPR person? Well, we're friends. So, but we have a good working relationship with all of them. And we're different. As you know, we're all the institutions have a different type of caseload. We're a different animal than JAMS. We're a different animal than CPR, and they know that too. They accept that. We're all different. I mean, we have our certain roles and expertise, and and we have all, I think, have great arbitrators and mediators.
No, it's great to hear that. It's always good to see collaboration drive in all fields of ADR, and it certainly makes for.
Yeah, I mean, the way I look at Elon is and I say to them, my colleagues and friends from these other institutions, we're all out there promoting ADR, and we all believe in this, and a lot of us have been at these institutions for many years, and if we can keep on promoting it, it's going to help. It's going to help JAMS, it's going to help AAA, CPR, FINRA, ICC. It helps all of us. So, when I'm out, pushing ADR, it helps all the institutions, as when they do too.
And I think it also helps the courts. I mean, for all of our judicial members that are, on the call tonight, I'm sure they're going to be, happy to hear that. We have a question actually coming in that sort of goes into the next area. With COVID, we're probably going to see an increase in litigation. We've already seen it to a certain extent with insurance and business interruption claims, and I'm sure there's going to be other claims, especially if anybody got the news with Amazon today, the suit that was filed with Amazon that they apparently didn't adopt adequate protocols for workplace safety. It's going to be in the news soon and heating up. So this is from William Bierce. Have you seen a major increase in demand for arbitration or mediation under COVID? In which areas? And then I'm just going to add a little quick add-on to this question also. Are there any plans for AAA to maybe have further involvements with the courts to alleviate their caseloads through the use of arbitration as opposed to just mediation?
Sure. Yes, we have. We've seen an increase, and we were surprised that, we're lucky. A lot of us on this call are the lucky ones in this pandemic where we can do our job and continue to do our job since the pandemic hit. But yes, we're seeing COVID claims. I think it's a couple hundred that we've seen since COVID specifically related. And I actually have a really high profile one involving a racetrack and business interruption, like you mentioned. And we've seen business interruption, insurance claims, not the bankruptcy stuff we're starting to see. So we are seeing them, and they're, like I mentioned, about 200 claims are coming in. So it's, are we going to see a lot more? I think so. I really think so. But the insurance claims, that's debatable. Because the insurance companies are saying, we're not going to, we're not going to allow these claims, but we'll see. But yes, we are seeing it, and I know the other ADR providers are, because I was on a program with some of them last week, and they said the same thing I'm saying. We're seeing them, but it's going to be a lot. And then I'm sorry, Elon, what was the other question about that?
Is there going to be any sort of plan on AAA's part to interact with the courts? Right now the courts do have ADR rules that provide for arbitrations, but they basically seem to focus more on the mediation aspects of ADR as opposed to referring cases out to arbitration. But with the deluge of all the COVID cases that has been talked about, are there any plans for AAA maybe helping out the courts to alleviate some of the backlog and also just to take off some of the pressure?
Absolutely, and we're reaching out to the court systems right now. What we're doing is we're contacting our arbitrators and mediators that have contacts with judges. We want to do a soft sell. We don't want to say that we want to take over your business. We want to say, hey, we're here. We can do it. And if you have a backlog, we're ready to help you out. Like that case I mentioned, that $1 billion case in, from Texas, a bankruptcy case. So yeah, we're here, and we're trying to get our VPs around the country to reach out to judges. I have a colleague of mine that right now is reaching out to some judges in New York to see what we can do, and just to say, hey, listen, we're here. We do this stuff. We can do any platform. And I think we could help out. And like I mentioned, the court system contacted us. I didn't contact them about the small claims stuff. They contacted AAA, and we said, sure, we'll reach out to our mediators. So I think all the providers have a good relationship with the court systems, and we want to work with them. And we're not trying to take their business at all. We're just trying to say, hey, if you are overburdened, we're here. And all the providers never shut down. So we're ready. We can do things quickly. And we have a lot of people at our disposal that can help out. So yeah, to answer your question, without a doubt, we're
right.
Working.
So I'm sure our judicial folks tonight here who are attending, they're going to be happy to hear that. All right, we have two more other questions that have come through. One from Diane O'Connell. Do you know how to get information on the Department of Financial Services program? Do you have a contact?
I do, and I can provide that. So if you want to, I'm going to put my email in here, yeah. And then afterwards I'll provide it. I'm going to do it right now. I'll put my email in the thing for everybody. It's Zaino J. And I don't have it off the top of my head, but I have it in my email somewhere. ZainoJ@ADR.org. So did I do it right? Is it there?
It's not. Did you send it to everyone?
Oh, no, I just sent it to one individual. Hold on.
Right.
All right.
That's usually the case after you hit enter.
There you go. Okay, so yeah, please email me with any questions or requests. And yeah, I have some contacts there, and you can just email them and find out what they're doing. And they're terrific. We've had a great relationship with the state. We did the no fault stuff, Storm Sandy, and now we're doing the civil unrest stuff. So it's a great relationship.
Okay, sounds very promising. Then we have another question from John Adam Kearns. How many mediations does AAA do a year nationally in the New York City area? Mediations.
I think about over 1,000, somewhere around there. We do a number of them. I mean, our business is primarily arbitration. We, as a company as a whole, not just New York, 80% of our business is arbitration, 20% is mediation. But I would say it's probably around 1,000 cases. I mean, I'm talking my area. I'm talking commercial area. With respect to like programs like Storm Sandy, and when we have up programs, there's a ton of them that are occurring. And the civil commotion thing, they'll inflate our numbers. But for the normal business to business stuff, probably around 1,000, somewhere around there.
Okay. That's certainly a lot, for doing that. And great. That's always, anything, 1,000 is a nice number, 10,000, whatever it is, but it's great to have that. Question that I think a lot of other people have, which I'm going to call the elephant in the room question. If you end up becoming a panelist with the AAA and any of the panels, commercial, employment, labor, etc., how do you have your compensation determined?
Great question. A lot of people don't know that answer. You determine it. You determine what your compensation is going to be, and you are an independent contractor. Independent. We AAA. We work for the clients. Okay, for the parties. We don't work for the arbitrators and the mediators. So we're not assigned to an arbitrator or a mediator. And basically, our focus is on the parties. The mediators and arbitrators are terrific. They're the face of the AAA, and they do a wonderful job, but they're independent. And we review them every 3 years, and we can rotate them off, based on anything, based on caseloads dropping, whatever, or they're not being selected. And they determine what they want. And what I do when I get a new arbitrator or a new mediator, and I talk to them, a couple every month, I say, listen, here's what you should potentially bill for the market. But it's your call. And then I get some people that say, well, I'm at a law firm and I'm making $1,200 an hour, and I want to bill that. I'm like, well, you can, but you're not going to get any cases. You're not going to get the smaller cases as a new arbitrator or whatever. The rate for a new arbitrator at AAA is usually around, in New York, I'm only talking New York right now, it's probably around $450 an hour. And then really experienced arbitrators are around $650, $700. Some judges are around $800, $900, maybe $1,000. But again, it's your call, and and you can change it. You can't change it when you're handling a case. Can't at the beginning of the case you're billing at $800 and then you bill more. You can change it at any point, and we don't control that. So
just a point then that Janice raised, just to as an aspect of clarification, she wrote, unless you were on the consumer panel, then it is a set amount. Or from what you just described, it doesn't seem like it is set. Maybe she means that it's a range.
No, she's right. On consumer, I don't do consumer because that's not considered. It's commercial, but it's not really commercial in my division. There is a set rate. I don't know what it is. Sorry, but it is a set rate. We have set rates for consumer. For expedited cases for New York, I think it's $1,200 for the whole case, and that's it. That's all you get. So if you sign up for consumer, expedited, it's a set rate, and that's what it is. Okay, I just see right now someone put 2,500.
Right.
Oh, thank you. Okay,
there we go.
Cool. Yeah, so
2,500 per consumer.
Thank you, Janice. I didn't know that. Okay, but
you do have flat rates, which is always interesting to note. Nelson had a question that he wanted to ask, I think, live. So Nelson, why don't you unmute and go ahead?
Oh, you're still muted.
Yeah.
Okay, so as we wind down, I wanted to ask you, I know that every place that you speak, everybody wants to know what you can do for them. That's just the reality of things. So I wanted to know what our group, the ADR committee, can do to help you to make your job a little bit easier. Is there anything that we can do, like volunteering for some of these projects or any other thing, having you come by periodically, or what can we do to help you, Jeff?
Thank you, Nelson. That's a terrific statement and terrific question. What you can do for the ADR providers, not just AAA, is obviously when we have these kind of mass claims, volunteer your time. I mean, and a lot of people did volunteer their time. And some people are doing pro bono work for AAA, not for us, but for the clients, and volunteer for that stuff. But also, if you have contacts for JAMS, for AAA, for CPR, if you have contacts in major organizations that are not ADR friendly, get us in the door. And I say this to our arbitrators that are new on our panel. I say, listen, it's a two-way street. We want to promote, and again, I'm not necessarily promoting AAA, I'm just promoting ADR. Let us get through the door to a company that you have some contacts at, or somebody that you know in a law firm. Let us go there and give a presentation like I'm doing tonight to talk about, and I'm not talking so much tonight because you guys all know ADR, but let us talk about the benefits of ADR. And there's studies out there that we've done, JAMS have done, CPR, FINRA, whatever, ICC. Get us through the door on those places, and that would help. That would help tremendously. And also, again, to volunteer for these programs when they come up. And I'm not wishing upon us more disasters that we've had, like Storm Sandy and this, what we're going through. But when those occur, please volunteer, and we're here to take volunteers. But get us through the door to explain to people that don't understand ADR right now. But yeah, great question, Nelson. Thank you.
And we also had a question from back a while. I'm going to go pick it up on the backtracking from Toby Dress Germain. The question is, can you explain a bit more about the civil unrest cases?
Sure. Those are cases involving a company that or a store or a vendor that has been looted or broken into, that has, I believe, under 100 employees. This is all state required. It's not AAA. The state required this. Under 100 employees, a small business involving the insured and the insurance company. And those are the cases right now. And we're not looking at a lot. We're looking at probably, I'm estimating about 500 cases or more, a little bit more. I think a lot of them are going to settle. I think the insurance companies will settle, but it's basically the insurance company versus the insured, and basically involving small business. This is not Macy's that was broken into, or Apple. This is involving small business owners. The state said that they want to introduce this program through the AAA because they worked with us with Storm Sandy and other programs, and that's what it is. And are we going to see a lot of cases with that? I don't know. I mean, we're starting to see people negotiating things with us about it, but it's I think it's a good thing that we're doing. I think it's a good thing that the state's doing. And the insurance companies are great too. I got to admit, with Storm Sandy, and I've been on a lot of programs about insurance stuff. The insurance companies really do want to pay out and help. They really do. I mean, they're not the evil people that a lot of people are making them out to be. I sat in through a lot of the mediations. They're trying to, come on. They're saying Storm Sandy was terrible. What happened with the civil unrest was terrible. Let's compensate these people. But that's what it is.
And then Leslie, I think, had a question. Are we talking about BOP, business owners policies?
Yes, we are. Yes. Yep. Okay. And right now it's premature for me to talk about the caseload. It's just starting. We immediately helped the state get this program up and running, but it's premature for me to talk about where we're at with things, because we don't really I don't have the data on it right now. But I'm glad we're doing it. I really am. I'm glad the state want to work with us.
That sounds like a great program. So let's hope that that certainly will, amongst your other efforts, will serve to keep conflict down and keep all of us in business at the same time, which is great.
Absolutely, absolutely.
I think we're about reaching, you know, the end. Actually, wait. I do see one more from Sarah Kula. I see what she's doing. Where she's referring to the consumer panel. I think you're going to say it's the same thing. Go to adr.org, but you know, maybe it's something different. Are there any special instructions for applying to the consumer case panel?
Yeah, I would just look on the consumer panel. I mean, on the adr.org, and if you can't find it, just email me, and I can direct you to my good colleagues in the consumer division. We have people in Providence, Rhode Island, and people in California that handle our consumer caseload, and my God, that caseload is going through the roof right now. Employment and consumer right now is booming at AAA. It's like, obviously we know why, because of what's going on.
And I just put your email address back there again. So I think that's essentially it right now. I just wanted to discuss one or two quick committee matters. We still do have 10 minutes afterwards. It'll take me about 3 minutes. I want to ask everybody right now to save the chat. We had a great chat. There's a lot of information, even even though this can be recorded, you do get stuff in the chat, including Jeff's email address, and then we have the adr.org address, as well as the file that I sent around. So to do that, for those people who may not be familiar with the feature, if you go into Zoom, on the chat function, that's Alt-H, right next to the file icon, you'll see 3 dots, and there you should see something that says Save Chat. If you don't happen to see that, or if you have a problem with it, don't worry. I can save you the chat afterwards, and so far as I have it, and I just saved it to a folder which is set out. But if anybody can, save their chat, especially if you have your own comments in it, I'm not going to save your comments that you did privately. I can't. That's one of Zoom's security features. So please do save the chat, especially if you sent around something privately, just so you have it. And with that, I'm just going to give the other quick announcements that we had on the agenda. We spoke about the upcoming programs, just because I know there are people who have to go, but I'm certainly, keep this meeting open for as long as anybody wants to stay on. And we do have another 10 minutes after this, but just very quickly, last month we had our committee meeting that we usually have, our monthly meeting, and we had 2 requirements that were put in. So one of which, by the way, everybody's meeting tonight who are members. There's a requirement now effective for 7 committee meetings or events during the 2020-21 committee year that runs from September through June. It's the traditional NYCLA time, so that's a requirement. And again, anybody needs an accommodation if you live abroad and what else, you still want to join, certainly ask us. We could waive it for you, but it's just expected that, we're putting together these things. We want people to come, and I have to thank everybody again for coming tonight. We had close to, I think, over 90 people at one point tonight, which was great. So thanks to everybody for coming out. And the other thing is dues. Like many other organizations, we do charge dues. Not a ton, but it's not a small amount either. But it does allow us to put forth this great program like you have tonight. It's $36 for the year. Someone asked me, does that have any correlation to the number 18? It does. It's double times the number 18, which in Jewish tradition is to life. So everybody should be safe amidst the pandemic. That's the idea. Twice over, double for that. You get double measure for that. But aside from the symbolic significance, and also we just did an economic, mathematical analysis, and even without our food that we used to have, hopefully we'll be able to have that, please God, sooner rather than later, when we have this pandemic finally quashed. But even without the food, we still do have expenses, and that's what the $36 is for as well. It allows us to put on these programs, as well as the great trainings at a discount, which are coming up. So those are the other 2 examples, the other 2 announcements that I just had. So again, you heard that you will be having a bunch of events that we're planning coming up. Please book our calendars for October 28th, November 11th. And again, for those, especially for those people who are special masters with the AD2D, we're offering a very big discount for that entrenchment training program. And with that, that's the official part of the meeting, but I'm going to keep it going. If anybody else has any additional questions for Jeff, we still got 10 minutes left, as I just said before. So anybody have any additional questions? Does anybody have any questions regarding the NYCLA ADR Committee? the other thing I just want to do before everybody goes, Jeff, thank you so much. We got a lot of comments in the chat saying this was a great presentation. That's an understatement. It was an extremely informative and useful presentation, aside from being great. So that all goes into it. I think everybody enjoyed it. I certainly did. It was something which we were looking forward to. And it's great that, again, so many people came out. So
Well,
thank you so much.
Yeah, thank you, Ilan and Nelson. I mean, it was great to be a part of this tonight, and I really appreciate it. It's a great opportunity, and I love your organization, and you guys are great leaders of this organization. Thank you.
Thank you so much.
Thank you very much.
And Chris, just why don't you pipe your head up just to say hi? Chris has been in the background actually sending around screenshots, which we'll be posting later on. We got some very good ones. We tried to get you without your eyes closed and smiling. We did get a couple ones, all kidding aside. So Chris, why don't you pipe in just for a second?
Yeah, hi guys. Thank you everybody for attending tonight. But of course, a huge thanks to Jeff for a very informative and knowledgeable talk tonight. I hope everybody enjoyed it. I certainly did, and I'll hand it back to Ilan.
Thanks, Chris. Appreciate it.
Chris is our Brooklyn guy.
Oh, cool.
By way of Australia.
Hey, we all have a lot of town halls to do tonight. I think both town halls are being done simultaneously.
And actually, in that regard, it's funny you mentioned that, because there actually is a way in Zoom, if anybody's interested, to, unless they corrected it, to accidentally, quote unquote, engage in crosstalk. We had one person at one of our trainings who was attending 2 separate Zoom meetings on one internet connection, and it so happened that it happened to be the second meeting was a children's birthday party. So in the middle, when we're running a divorce mediation simulation about the division of the asset, all of a sudden we hear, "I want some cake too." And no one knew where this was coming from. So hopefully they don't do that with the town halls tonight. Each one of
it's going to be interesting tonight. Yes.
Yes.
And I see Linda said thank you because she's from Connecticut. But Linda, I'm from Connecticut too. I grew up there, and I deem Connecticut to be part of New York. Connecticut, New Jersey. So thank you, Linda.
Yeah, it's great that the internet allows everybody to get Zoom, and allows everybody to get together like this. One other point, by the way, that I should mention is right behind me. Mediators Meeting Online. That's another project of the New York County Lawyers Association. You do not need to be a member of the committee in order to join that group. That's a group of mediators from all over the world, everywhere and anybody, for 1 hour on the 4th Tuesday of each month. That's going to be October 27th. So that's one day before the starting and maintaining an ADR practice in the age of COVID-19 and beyond, CLE. It's completely free, which again is given to us by the resources of the New York County Lawyers Association. So that's what your dues help to go towards. That has been a phenomenal resource, and we actually have a Google Doc. I mentioned it before to Jeff. I'm going to put it in the chat very quickly if anybody wants to see some of the topics that we discuss. They range, from the advantages of ADR and ODR to technical issues dealing with people in waiting rooms and Zoom advancements, and the gamut, goes from here to there. We've actually had some very poignant meetings as well. When Judge Deere, of blessed memory, unfortunately passed away, we actually did an online tribute to him that was read out. So there's certainly been some emotional moments as well. So if anybody's interested, the MOO Google Doc, and we'll just put it in the chat, is located here. And you can see what we deal with. But again, everybody and anyone is invited to join that. And yes, for those people who are focused more on arbitration, once in a while we also deal with arbitration. The focus is primarily on mediation, but as long as you follow the rules for putting in your topics, we ask that you put the topics in advance by going to that Google Doc, and then we grade them out as we discuss them. We've dealt with arbitration issues before, and it's actually one time we even discussed in brief a presentation that was done by Justice Bellin out in JAMS, where he was talking about using ODR techniques for arbitrations and how we could use that to then deal with mediations as well. There's a lot of crossover, and it's great to see that AAA is getting to that field as well. It's certainly the wave of the future. Okay, so I think that's basically it. We got 4 more minutes. So, you know, Jeff is here. Now's your chance. Danielle, you have your hand up. Wonderful. It's the first person tonight who actually used the hand feature.
Yes.
That's cool. All right, so Danielle, go ahead. Get on mute. Danielle, I still see you're here. Hang on, let me. Have you unmuted? Danielle, you have to hit Alt-8 on mute. Let's see if I can. Okay, maybe she stepped away from her. I see you're in the gallery right now. Yep, she must have stepped away. All right, well, anybody else have? Oh, actually, I see there actually, ironically, is an Amy Barrett with us tonight. So it's always nice to see that. I don't think that's the. That would be Amy Coney Barrett, but it's like that. But I think she's from New York. But if we do have a question from Cheryl Messina. As a AAA arbitrator, is there an ability to buy into group health insurance? Okay, good question to the end off.
No. Unfortunately, no. I mean, we deem our arbitrators to be independent, but not employees of the AAA. You know, no. I mean, and I'm not sure if any other provider does that either, but definitely no.
Okay, so that's the quick answer to that. Anybody else have any other questions for Jeff? Something like that? Oh, okay, William, go ahead. Yeah. No, you're just well, you can unmute at this point. Why don't you unmute if you wanted to say something? I should say questions, comments, and observations. Hang on. William, you have to hit Alt-A.
So thank you, Jeff. Great job. We are all inspired to work with you, and we appreciate your insights and your coaching and your help. And really, you're helping everybody, and you're helping the litigants and calming the Sturm und Drang in the street.
Thank you. I appreciate it, William. I really appreciate that. Thank you.
Okay, so with that, we're at 7:58, and we're basically at the conclusion of our meeting. If anybody, again, wants to join the ADR committee, first, again, I want to thank Jeff for the wonderful job tonight. Thank you so much. And if I have my clapping hand over here, I'm going to give you that one, and I'll give you the party hat also. You know, it's great that you're involved in this whole thing. So thank you for that. And by the way, Zoom apparently now, from what I understand, is introducing studio effects to various virtual backgrounds that you have, so you can actually dress yourself up. I think just to show you what I'm talking about.
Could I put some hair on my head?
Yeah, that's what I was going to say. They have stuff like that apparently, where you can add in like a mustache and beard. I don't know if you see something like that. There's a horseshoe, a chevron mustache, and just gave myself more of a scruff than I just did.
Look at Chris right now. Chris put something. But Chris, we'll talk later about doing hair on our head.
Right. So I was about to say, eventually you can do that as well. They were talking about that today. Zoomtopia, certainly a interesting way to keep meetings fun and avoid Zoom fatigue as a practice. But all kidding aside, thank you again so much for coming tonight. If anybody wants to join the ADR committee, please send an email to me. You have my email address. It's eweinreb@weinreblaw.com. You can see that from all the invites that you guys got, or alternatively, contact Chris or Nelson. And again, requirements, so you heard them tonight from what we had before, $36 for the year, and just attendance at these events and programs, easily done, considering you already have 3 of them, inclusive of tonight, coming up within the next 2 or 3 months. And it's just a phenomenal opportunity for ADR. Also, we were talking about people asking about experience. Just a quick plug for the Part 137 program. NYCLA's Part 137 program is one of the only ones in the state, if not the only one, that handles both arbitrations and mediations at the same time. And for those people who actually want to get panel experience as being part of a tribunal, a 3-person, the threshold is much lower than AAA's. You only have to have a case where the amount of controversy is $10,000 or higher, from $10,000 to $50,000 in Part 137 to have a tribunal. And you will have the opportunity to work with non-lawyers, because in tribunals, three-person panels under Part 137, the rule is that one of the arbitrators has to be a non-lawyer. So it's a great experience. I've done it before. I've been a chair. I've been a wing. I've served with people who are junior to myself. I've served with people who are senior to myself. It's just a great opportunity. And again, watch your calendars in December. December 9th is going to be the first day of that program. And then there'll be another day afterwards. The first day will be focusing on the arbitration aspects of Part 137 cases. And then for the first time, we're actually going to be focusing on Part 137 mediations, which is, as far as we know, has never been done before. So it's its own day in training. It's a half day, really, but it's going to be certainly robust and a lot of great information and role plays, by the way, as well, for those people who are seeking role plays for Part 137 mediations. And yes, Nelson just put in Part 137 is attorney-client fee disputes. It is a pro bono program, but it's probably one of the best, if not the best way to gain panel experience as an arbitrator, if you want to see what it's all about. And it's just a lot of fun also. So that's my plug for that. And again, we're at time now. So last chance, if anybody has any questions for Jeff. All right, looks like that's it. Jeff, thank you so much again. I wish everybody well, and do stay safe. And again, last chance now, do save the chat. I'm saving mine right now by going to the chat dialog. That's Alt-H and the three dots. Click on the three dots and go to save chat. And with that, I wish everybody well. Good luck with your respective cases and your endeavors. Have a great night.
Thanks,
Stay
guys.
safe, everybody.
Thank you so much. Bye-bye.
Bye-bye.